And good afternoon to all of our attendees. We're excited to have you with us for this program today. In a way of very short, informal introduction, I've been with Ellerby Thompson since 1993, so that's a long time. And I'll say, with respect to this program, that it is dated as of today, July 27th, and what we're going to do is provide some information for you and a few scenarios at the end and things like that with respect to COVID-19. As we all can recognize, I hope, COVID has presented us with a very fluid situation. So I highlight that this is July 27th because this is a recorded program and things are changing, as I'll reference in some of the slides I'll address later on. I think we're coming from a position when a lot of businesses were opening back up and people felt pretty good and like, hey, this is great. And now, given the Delta variant's rise in a lot of jurisdictions, we're starting to see some question of, do we have to go back to mask again? And are we going to have to go back at some point in the future to virtual work? I wouldn't throw your playbook out. So I'll just throw that out as a general idea. But what we're going to focus on today is just kind of the legal lay of the land with respect to COVID-19 and the local government employer. Also want to highlight that this presentation is training, not legal advice. If you need legal advice, that's going to be based on the nuances of your particular situation, whereas this is more general information. And I'll credit Tim with doing a great job putting this program together. We've got it organized into kind of three broad areas for you. And Tim, if you'll go to the next slide. Here's your roadmap for the day with little COVID-shaped virus particles there. We're going to talk about some vaccine policies, whether it's a mandatory policy versus an encouraging or incentivized policy. You'll see that in the news right now, there's a lot more conversation about implementing mandatory policies than there was even like 2 or 4 weeks ago. So again, this is a very fluid environment, but we'll talk about the differences between mandatory versus encouraging approaches. We'll talk about the idea of requesting proof of vaccination and what you do with that proof. As we go through those various things, we'll contrast treatment of vaccinated versus unvaccinated employees, which is becoming more and more of an issue for various of our clients within the public sector and private sector. And then we're going to wrap up with some return to office considerations. Again, these are practicalities that will vary from work environment to work environment. So again, this is not legal advice, but just general information for your consideration and our discussion. We are going to try to wrap up our comments, but with about 10 minutes left so that there's time for some questions at the end. So with that general roadmap, I'll turn it over to Tim for a brief introduction and to take it from here for the next few slides.
Yeah, thanks, Patrick. As Patrick said, my name is Tim Holdsworth. I've been with Ellerby Thompson only since 2018, so a little bit shorter time, but I've been practicing longer than that. And in that time, I've been advising private employers, public employers on all sorts of employment-related advice, employment-related litigation. And so, we're very happy to be here with you today. As Patrick said, the first thing that I kind of want to talk about is vaccine policies, and in particular, mandatory vaccines. As Patrick kind of alluded to, we are seeing, I think it has to do with the Delta variant wreaking more and more havoc recently, but we are seeing a lot more employers wanting to institute mandatory vaccine policies, certainly more so than there have been dating back to when the COVID-19 vaccine was kind of generally available to the public, when we're talking back in March or so. So we're seeing a lot more of that recently. Even this morning, I think I read that the Department of Veterans Affairs is going to require it, and then California is going to require it for a lot of their employees. So I want to take through kind of what we need to be worried about. Here's, there have been some lawsuits so far over mandatory vaccine policies for employees. And so one you might have read about was in Houston, Texas, to deal with hospital workers over a vaccine mandate. Another, San Francisco, announced that they were going to require employees to get vaccinated. Some of these policies have been challenged. Some have not yet. We're seeing generally in the cases that have reached kind of an initial order by the judge, we're seeing that these policies generally are upheld, but the legal theories on which they're challenged are kind of all over the place. So it's important for all of us to know exactly what are the types of challenges that we have seen and what are the types of challenges and main topic areas that we may see as these become more widespread and as they become get more challenged. So as to the considerations that you have to have in mind, first, from kind of a legal statute perspective, two of the big ones are Title VII and the Americans with Disabilities Act, the ADA. Now, under Title VII, we're really talking about religion, because as we have seen recently, there have been some religious objections to some of the mandatory vaccine policies, and likewise, there have been some disability-related objections to mandatory vaccine policies. For a long time there, until a couple of months into the year, just fairly recently, for a long time, as the vaccine became more available to the general public in the early parts of this year, the EEOC, which kind of handles the federal EEO laws, kind of was sitting back and not really giving much guidance about whether they believe that mandatory vaccine policies were allowed, under what types of parameters those would be allowed. Luckily, very recently, they have come out and given us some guidance, but before that time, there was a lot of discussion of, well, this is what the EEOC said back when we were dealing with some Ebola issues. Now, obviously, any of you that may remember the Ebola situation, that's obviously completely different than what we're dealing with COVID-19. So to a certain degree, those types of guidance, that guidance that was issued around the Ebola threat may not have been applicable. But like I said, very recently, the EEOC has provided some additional guidance, albeit very generalized. Now, the other things that public employers have to worry about is the due process clause, and whether there is a liberty interest, and also the free exercise of religion clause. We'll talk about that in a little bit more detail. But starting out with the legal statutory framework, the Americans with Disabilities Act, under that act, an employer may require an individual with a disability to meet a qualification standard applied to all employees, like a COVID-19 vaccine requirement, if the standard is 1, job-related, and 2, consistent with business necessity. Now, if the particular employee can't meet that standard because of a disability, the employer can't require compliance with the policy, such as a mandatory vaccine policy, unless that individual would pose a direct threat to the health or safety of the employee himself or herself or others in the workplace. Now, what we have seen, that's obviously the general framework of what we're talking about. What the EEOC guidance has recently given us is that COVID-19 does meet the direct threat standard. So that means that an employee that would be unvaccinated to COVID-19 would be a direct threat to the workplace health and safety of others. But the analysis doesn't end there, because as we all know, under the ADA, we have to provide, employers must provide reasonable accommodations to employees with disabilities. Now, under the ADA, yeah, a policy, a kind of generally applicable policy like a mandatory vaccine policy for COVID-19, you'd have to be required to exempt any employee who, because of a disability, is unable to be vaccinated. You have to provide a reasonable accommodation, and that may include exempting the employee from vaccination. You're probably familiar with the interactive process that the employer has to engage in with the employee to determine whether a reasonable accommodation to a policy like a mandatory vaccine policy exists. In doing so, the employer has to consider whether providing a reasonable accommodation absent an undue hardship would reduce or eliminate that direct threat. Now, in terms of again, just talking about the general framework, in considering whether in entering into the interactive process with the employee, first it has to be confidential. And what can this process look like? Well, it would be a confidential review process that applies consistent standards for medical exemptions, such as requiring a doctor's note related to both the existence of an underlying disability, so that the employer can actually determine whether this employee does have a disability under the Americans with Disabilities Act, and two, what the relevant medical contraindications would be to getting a COVID-19 vaccine. So the reason, i.e., what that means is the reason that the employee can't actually take the vaccine. In entering into this interactive process to try to identify reasonable accommodations with the employee, there are various there could be various accommodations that you could discuss with the employer can discuss with the employee about accommodations that could be made that would exempt the disabled employee from the mandatory vaccine policy. Now, some things that we're likely to see in situations like this is, would a reasonable accommodation be allowing the employee to work remotely? Would a reasonable accommodation be working outside of the regular business hours so that you cut down on the amount of possible cross-contamination and interaction that employee could have with others in the workplace? Or it could be a leave of absence for the employee. We have seen that on occasion, that a reasonable accommodation could be letting the employee take a leave of absence from work. Now, that last one probably depends a little bit on what the contraindication would be for the employee. Maybe it's something that is happening right now but may not be permanent. Some things like that you just have to, that's why it's important to enter into the interactive process to identify what could actually be a reasonable accommodation from the mandatory vaccine policy. Now, this interactive process requires an individualized assessment regarding the cost and how burdensome the accommodation would be to the employee. Moving on a similar basis, Title VII prohibits workplace discrimination in the terms of condition of employment on the basis of religion. Very similarly to the ADA, any policy may require an individual to meet a qualification applied to all employees, like a COVID-19 vaccine requirement, if the standard is job-related and consistent with business necessity. Again, the exemption, any exemption that you're talking about, if an employee can't meet the standard because of a sincerely held religious belief, the employer can't require compliance with that policy unless the employee would pose a direct threat. It must provide a reasonable accommodation unless uh, doing so would cause an undue burden. Excuse me. Now, dealing with situations like that, a lot of times what some employers get hung up on the sincerely held religious belief, especially if the belief does not fit kind of what the employer traditionally thinks that, if the belief is that I can't be vaccinated, but that the employer doesn't think that that is an actual religious belief for the person, sometimes the initial reaction is to question the belief. But frankly, on these, as a general matter, the employer shouldn't focus on the sincerity of the religious belief or challenge the belief unless there really is an objective basis to do so. A lot of times, frankly, it's very difficult for the employer to show that a religious belief is not sincerely held or sincere, and kind of the parameters for an employee demonstrating a sincerely held religious belief is relatively low. Again, you're going to, under this, again, we're talking about general framework. Under this statute, the employer is required to provide for an interactive process, engage in the interactive process with the employee to determine whether a reasonable accommodation exists to the, in this case, mandatory vaccine policy. Again, you're going to be, you're going to be looking at some similar things. What is a reasonable accommodation? Again, working remotely, working outside regular business hours. Maybe there's a leave of absence. The employee can go on a longer leave of absence. The undue showing undue hardship under Title VII, the undue hardship standard is much lower than it is under the Americans with Disabilities Act. So here, an undue hardship would be just a de minimis cost, something that may decrease productivity. Frankly, the undue hardship standard is much lower for showing that an employer wouldn't have to accommodate a religious belief than it would under the Americans with Disabilities Act. Now, moving on to some other things that we have to consider. First, some of the constitutional considerations. The Due Process Clause of the 14th Amendment protects individuals' right to interest in life, liberty, and property from state and local government intrusion or interference. That is kind of broken into two components, first procedural and then substantive. The procedural due process component requires certain procedures to be followed relating to the provision of notice to the person affected and an opportunity for him or her to be heard with regard to the proposed interference. In this instance, the proposed interference would be requiring a vaccine to be in the workplace. The other component is substantive due process. That means that the government interference here, the mandatory vaccine policy, has to be justified. And the applicable legal standard that applies under substantive due process kind of varies depending on the relative importance of the liberty interest involved. Historically, the Supreme Court of the United States has found that a compelling government interest, that there is a compelling government interest in protecting the public health and safety, particularly during epidemics. Frankly, compulsory vaccination laws have generally been upheld, but a lot of those, unfortunately, are not exactly on point for employees and employers in the context that we're kind of talking about with mandatory vaccines in the workplace. Most deal with children having to be vaccinated to attend school, so not directly on point. But in those cases, one thing that we can take from a lot of that is that in those cases, the right that's involved, the parents' rights to make decisions affecting their children, the liberty interest involved, that's actually subject to the highest level of scrutiny. So what that means is that that's going to be the hardest standard for the government to meet in that situation. So what we can take from that is that even if an employee's decision affecting their own bodies, the liberty interest involved here would also be evaluated under the highest level of scrutiny. The highest level of scrutiny has still found that there is a compelling government interest here. Now, in addition to showing that there's the compelling government interest, the second part is that you have to show that the policy is narrowly tailored to accomplish its goals without unnecessarily interfering with liberty interest. And what that means is that there's no alternative means available that would be equally effective in achieving the policy's objectives while infringing less on liberty interest. In the context of mandatory vaccine policies, some have suggested that in order to meet that second prong, the narrowly tailored prong, some have suggested that the policy should only cover employees who are required to report to the workplace or interact with coworkers or members of the public, or whose duties and responsibilities would cause them to pose a direct threat to the health and safety of others if they aren't vaccinated. So this almost kind of dovetails back into the ADA and Title VII considerations, in that the narrowly tailored requirement may not allow you to require an employee that works remotely, for example, to get a COVID-19 vaccine, because that person wouldn't, at least on their face, on its face, that situation, that employee wouldn't pose a direct threat to the health and safety of others if they're not vaccinated. Another kind of the last thing that we haven't been seeing this as much in some of the litigation that's come up, but it certainly is an idea that gets thrown around a lot when we're talking about anything that's mandatory, is the free exercise of religion clause. The Supreme Court has held that the free exercise clause of the First Amendment prohibits government interference with religious beliefs and, within certain limits, religious practice. Now, all this requires is that any type of policy, like a mandatory vaccine policy, is neutral on its face and in its origin. So it's not implemented for the purpose it's not implemented for the purpose of going after a particular religion. It also must be of general application, and unlike Title VII with employees, there is no accommodation obligation here. In that sense, the Supreme Court has kind of found that the free exercise clause of the First Amendment, any type of accommodation, to the extent there is one, is just being able to vote for representatives that would establish legislation that would, be of more particular application to, not requiring certain things, not requiring certain interferences with religious beliefs and religious practices. So all of that, how does that play into exactly what an employer should be thinking about when they're actually drafting a mandatory vaccine policy and implementing that policy? Well, one, any type of policy should certainly be, and it probably also wants to state that it's adopted for the purposes of promoting public health and safety by protecting its employees, the public employees, residents, and community at large from the spread of COVID-19. Second, you also want to make sure that the policy is of general application. facially neutral, not adopted for the purpose of disadvantaging any person or class of persons due to their disabilities, religious beliefs or practices, or any other protected status of activity. Third and fourth, to cover the due process concerns, you also want to make sure that the policy is narrowly tailored to accomplish those health and safety related goals, and it remains job related and consistent with business necessity, but with due consideration still given to whether there are less burdensome means to which the goals may be accomplished. Here, the goals would be the health and safety related goals of the COVID vaccine. So, as I mentioned before, that may mean that some of your remote employees, some of the employees that don't necessarily have to interact with coworkers a lot, don't have to interact with the general public a lot, maybe a narrowly tailored policy would involve exempting them from the mandatory vaccine policy. Any mandatory vaccine policy would also expressly allow employees with disability or religious-based objections to the mandatory vaccines to request exemptions, and provides for a confidential review process by which such requests can be meaningfully evaluated. That confidential portion is really important. Sometimes in these situations, you deal with an employee that makes it very well known that they have an objection to the mandatory vaccinations. That's fine if they want to tell others, but employers need to realize that they need to keep the review process confidential and not involve anyone that isn't necessary to actually have the review process and evaluate the objection and request. The policy, you're also going to want to make sure that the policy provides for or allows the local government employer to engage in an interactive process with each employee exempted for the purpose of attempting to identify a reasonable accommodation that would enable the employee to perform his or her essential job functions without posing a threat to the health and safety of himself or herself or his or her coworkers, or impose an undue hardship on the employer and its operations. Lastly, one of the last things is that you want to make sure that the policy is applied and enforced uniformly with regard to all employees. That's kind of common, that's standard stuff. Lastly, because there is that the policy would allow employees to make certain objections under certain situations, and provides for the confidential review process, you want to make sure that you're training supervisors and department heads on how to actually identify when such an objection or request has been made. That's important because you can't, if your supervisor or department head is not really aware of that, of exactly what the type of request is, then that's going to be, that could cause some problems on the back end. Lastly, one last thing you want to think about is that you want to make sure that any policy isn't actually causing a disparate impact on any protected class. So you want to make sure, for example, that the policy isn't disproportionately causing you to terminate a disproportionate number of African American employees, for example, if they are deciding if a number of your African American employees are deciding not to get vaccinated. You want to make sure that you are keeping track of some of that information, so that if anyone does, if anyone does on the back end allege that there was a disparate impact to a protected class based on the policy, that you want to make sure that that you have the information to dispute that, or if you find out that it is causing some sort of disparate impact on protected classes, then you want to make sure that you deal with that before any type of claim is made. With that, I'm going to turn it back to Patrick so that he can talk a little bit about encouraging vaccination or vaccine incentives.
Thanks, Tim. And since we are making kind of a philosophical break between mandatory policies and encouraging or incentivizing approaches, let me ask you to do a hand raise exercise. If you've got the hand raise button that you can click, if your organization has implemented or has even considered implementing a mandatory vaccine policy for at least some of your employees, if you could click the hand raise button. I'm just going to see how many are popping up here. Well, I'm not seeing any so far. So if your organization has implemented or has considered implementing an incentive for the vaccine, raise your hand. Let me see how many of those we get. Well, maybe the hand raise thing isn't working because I'm not seeing any hands on that either. Yeah, no hand raises on that. So maybe we'll work on that and maybe ask it again later in the presentation. But part of what you see on your screen there is that in a recent survey, 80% of employers are not planning to require vaccines. That is a recent survey, but we heard in the last week that the Veterans Administration said, yep, we're doing it. We're requiring vaccines of our healthcare workers. So I think as the Delta variant becomes more prevalent in a lot of different areas, this is something that I expect to see more of, particularly in the federal government sector, with different agencies, federal agencies saying, you know what, we're going to do this, because I think the current administration is behind the notion of getting as many people vaccinated as possible. They're trying to encourage that in different ways. They've been sort of approaching vaccination from almost a begging standpoint, please get vaccinated. And now I think they're trying to take the approach that, look, we're just going to mandate it for certain kinds of workers and certain agencies. And so I would expect that 80% number of those who are not planning to require vaccine to go down if the Delta variant continues to be the problem that people anticipate it's going to be. If you have an incentivized or encouraging kind of approach or policy, the EEOC guidance dealing with ADA, GINA, those sorts of laws, and Title VII, as Tim addressed, those kind of break things down into two camps. If you have an employer-administered vaccination program, then you can't offer a substantial or coercive benefit. So if you said, everybody who gets a vaccine, we'll pay you $10,000. Well, a lot of people wouldn't want to pass that up, and so they would want to participate. And if it's an employer-administered vaccination program, part of what you always have to do before you get the vaccine is answer health-related questions. And that's where the ADA comes in, that you're asking information about people's health as an employer, and because you're asking for that information directly from them, you're subject to kind of the limitations that exist for, it's a quasi-wellness plan, even if it's not directly connected to your health plan, it sort of amounts to a wellness plan. If it's a third-party provided vaccine, the coercive limitation doesn't apply. But of course, if you offer $10,000 per person for those who got a vaccine, I imagine your citizens would say, hey, wait a minute, that's our tax dollars. Don't pay that much. And Tim, if you'll go to the next slide. Here are the kind of list of things that we've seen most often and that you'll see in various articles that have been used as an incentive to get people to get a vaccine. Very early when vaccines were being offered, you may remember that Kroger kind of made news as one of the first to announce that it was going to offer incentives to its employees to get a vaccine. And we've seen in the public sector people offering additional PTO hours or maybe even a PTO day, various things like that that would end up as an incentive to folks. And to a greater or lesser extent, it's helped. I think we're not all in a position to be like Ohio and have a lottery so that if you get a vaccine, you're entered in a lottery to win, I think, $1 million. But these sorts of things of even not docking pay or providing extra time to get the vaccine and recover if you have any side effects, those things have been seen to work. I can tell you that from my own experience and from everything that I've seen within the state, we haven't seen a direct challenge that any of these things is problematic under any of the laws that we've been discussing. So I think everything on this page is, if you were to do this, you wouldn't be on your own in doing it. Not to say that you wouldn't get challenged, but these are the things we've seen that have been fairly widely implemented and haven't caused a problem. So now we're going to move from mandating vaccine versus encouraging vaccine to a new topic of requesting proof of vaccination. And again, there's some overlap with part of what Tim presented in his first section. Tim, if you'll go to the next slide. Some of the considerations that he discussed before about, the EEO laws, the, Title VII, ADA, those sorts of things, those are implicated here with requesting proof of vaccination. The constitutional issues that Tim went through in terms of due process and free exercise of religion, those are implicated with a request for vaccination, proof of vaccination, just as if you were requiring a vaccination. So do be mindful of that. If you'll go to the next slide, Tim. Yeah, here's where the EEOC, as many of you probably know, has an FAQ document, and that gets updated periodically. I think the most recent update I'm aware of is from late June. This EEOC guidance permits employers to request proof of vaccination, and it says that ADA, Title VII, and GINA don't prevent that, so it's fine to do it under those laws according to the EEOC. But once you have the information, you have to keep that information confidential pursuant to the ADA. So what that means is two things. One, don't put it in somebody's personnel file, because I think the understanding from the EEOC's perspective is that lots of people can have access to somebody's personnel file for various reasons, and you don't want to have their medical information housed there. So it should be in a separate medical file or even a separate COVID file, so it's not mixed in with like leave documentation if you have that in a medical file. So that's one thing. The second thing is it is confidential. And the standard, which is sort of vague, but it's a little bit, it's been clarified over the years, is you can only share this information with those who have a need to know. And that would be, for example, if you can imagine sort of a cascading set of information, HR may have everybody's vaccination information, but if you give information to a department director, that department director can only have information about that department director's direct reports. And then the manager beneath the director would have a shorter, smaller list of only the people that report to that manager. Because if you have a policy, for example, that says, if you're vaccinated, you don't have to wear a mask. But if you're unvaccinated, you do have to wear a mask. And we're attaching penalties to this that we can write you up, we can issue discipline. The people who administer that needs to know who's who. That's a need to know the information so you can share it with them. But when you do, or if you do, make sure you advise them that this is confidential medical information. Don't print it out and leave it on your desk. Don't leave it up on your screen when you walk away. Take appropriate precautions to make sure this stays confidential. And the last caveat on this slide, warn employees not to provide medical or genetic information as part of their proof. Sometimes people, a supervisor might just go through and poll their employees. Well, if you take that approach, make sure the supervisor tells the employee something like this. Without telling me why, give me a yes or no as to whether you're vaccinated. That way, an employee doesn't say, no, I'm not vaccinated. I can't be vaccinated because of this medical condition. Then you're on notice that the person has a disability, and that could arguably constitute a disability inquiry. So you don't want to go there. What we found to be effective is either an HR-led survey of all employees, so you don't have individual supervisors kind of going about it differently, or using a computer-based radio button kind of format where the only choices are yes or no. And that way somebody can't say, why they're yes or why they're no. You just get the yes, no information. And then you can follow up on the no's with respect to, are you in status? Like, do you have one shot and not the second shot? Those sorts of things. But those are the approaches that we have done. And since we're talking about all these acronyms with ADA and GINA, I'll say on this slide too that there's been some publicity about HIPAA. Tim and I were talking about this before the program today, that HIPAA is not implicated here if you're asking an individual employee, what is your vaccination status? HIPAA might be implemented if you were to ask the person's medical provider about their COVID vaccination status, but if you're just asking the employee directly, HIPAA doesn't come into play. So hopefully that will sort of address that concern. Next slide, Tim. Thank you. Some of you may have seen that in late May, the governor issued an executive order that on its face applies to state agencies, state service providers, and that sort of thing. But in that last bullet point, you'll see that this raises the notion of it might restrict individual liberty and force Georgians into disclosing private medical information. This is, again, Tim addressed the liberty interest issues, but this is something that may prompt some conversation among people that might not otherwise have even thought about a liberty interest. But this executive order, which again applies to state agencies, state service providers, and state property, it doesn't apply to cities and counties. But still, you may hear some of these questions or things like that. Next slide, Tim, if you would. Thank you. This is just a kind of reminder of some of the things we've addressed already. We've touched on that first bullet point. The second bullet point, make sure you have a record of proof as securely as possible for that medical information. You do want to ask for the bare minimum. Just the vaccination card is really fine. On the don't column, don't ask follow-up questions about why somebody isn't vaccinated, because that could lead to the disclosure of a disability. You're better off in general not to know those medical details about your employees. And of course, don't share vaccination status with other folks unless you've got some sort of authorization. The same really applies with somebody's COVID diagnosis. You don't want to, the general EEOC stance is don't indicate that employee A has COVID or had COVID and you were exposed to employee A. Instead, you would generally say to an employee or a group of employees, you have had exposure to an employee who's tested positive for COVID. You should take appropriate precautions, without saying it was Jane Doe. You should, that's the EEOC's preferred approach. But if an employee says, look, I want you to be able to tell people, have them send you an email, something where you've got a record that they authorized the disclosure of their identity in connection with the positive COVID test. So I'll turn this back over to Tim now to discuss some return to work concerns.
Yeah, thanks, Patrick. Now, this last portion is really, we just wanted to focus on not necessarily, if you are requiring a vaccine, not necessarily if you're just incentivizing vaccine, not necessarily if an employer has not even discussed what they're going to do about the vaccine. It's more considerations for what to do in your actual workforce when you have a mix of both vaccinated and unvaccinated employees. What are some issues you may have to deal with? What are some steps you can take? Things of that nature. Now, we already talked about kind of the reasonable accommodation issues that you may have to deal with. So those are still there when you are initially talking about bringing people back to the office. There may be some discussions you'll have to have with employees if they object to coming back to the office based on disability. Especially based on disability, but there are some situations where a religious practice or belief may lead to an objection to coming back to the office. Now, you all have probably seen this chart that's been put out. The CDC seems to update it every couple of months. you may have seen it ad nauseum and before, but importantly, what isn't what isn't addressed in this chart is activity related to work, especially if you have a workforce of some vaccinated and some unvaccinated employees. So if you're in the majority and aren't requiring vaccinations, what steps can you take with a workforce of both, of kind of a mixed workforce of fully vaccinated and unvaccinated folks? Now, OSHA has said that most employers no longer need to take steps to protect their fully vaccinated workers who are not otherwise at risk from COVID-19. Now, OSHA doesn't have authority over public employers, but frankly, OSHA is one of the few entities that has issued guidance that's for mixed workforces. That could be helpful to kind of look at, even though it's not necessarily binding. So some of the things, frankly, I'm not going to go through all of these, but frankly, what OSHA has said is kind of maintain the status quo. So social distancing, encouraging washing hands, covering mouth and nose when sneezing, and continuing to use face coverings even after vaccination. An important thing that OSHA says too is that there should be a case-by-case review. That employers should be ready to conduct a case-by-case review for deviations from the general requirements there, social distancing, wearing a mask, stuff like that. So some of the putting in practice some of that thing, what are the situations that you may be dealing with? Take for example, all employees in a particular department are vaccinated, and no outside visitors come into that workspace, into that department's workspace. Under this situation, could the employees be excused from wearing masks and social distancing when they're working in the department? Under some of the things that OSHA has said, it could be, it wouldn't be unreasonable for the employer to allow them not to wear masks and social distance just within their own department. Now, that is something that the employees may be interested in. Not every employee in that department could be asking for that same kind of recusal from the general guidelines and general requirements. But that's why it's kind of important to have a case-by-case kind of review in place for deviations from that. And so, as another consideration, suppose all employees in a particular department are vaccinated, but the department occasionally interacts with vendors. This department, unlike the other department, does have occasional interaction with vendors. So if all the employees in Department B asked to be excused from wearing masks and social distancing when they're working in the department, should an employer allow that? Any thoughts out there? Well, one thing you may want to think about is, maybe we need some more information about what the interaction with vendors is. Is this kind of a face-to-face interaction? Is the vendor just kind of, bringing in some, new jugs of water for the water cooler, and they don't actually interact with anyone, and they don't get within 6 feet of anyone? Well, then maybe in that instance, they could be excused from, wearing masks and social distancing, even though the vendor's there. But, if maybe it's a different type of situation where there is actually kind of face-to-face interaction with the vendor, maybe you can allow them to be excused from the requirements, except when the vendor's present. Definitely just some things that you have to that employers should be taking into consideration when kind of dealing with this kind of mixed workforce. Just kind of one last thought, because this is, the big issue that you kind of have to deal with. As we discussed before, reasonable accommodation is a big issue you have to deal with. Some of the things that you may be dealing with from an ADA standpoint, first off, the the EOC, the ADA only requires that an employee be entitled to a reasonable accommodation, not necessarily that employee's preferred accommodation. So if an employee that has had an accommodation asked to continue to work from home because of a disability as an accommodation, maybe there's a different accommodation that's just as reasonable that still gets the employee back in the office, but the employee doesn't prefer that. Well, you're not required as the employer to give the employee the preferred accommodation. Another thing is that the ADA doesn't require that an employer accommodate an employee without a disability based on the disability-related needs of that employee's family member or other person that they associated with. That being said, if you still do, if you decide to give some sort of accommodation to that person because of their because of someone that they know that has someone that they live with, for example, that has a disability, make sure that you are kind of giving accommodations in that situation on a consistent across the board basis, and not so that the employer can't be accused of any disparate treatment. Lastly, just because the ADA doesn't require you to continue to allow a certain accommodation just because you've done so in the past. And just because telework for your entire workforce might have happened because of COVID-19 restrictions doesn't mean you continue to have to give telework as an accommodation going forward. So you're not necessarily locked in just because of what you've done in the past. Also, generalized fears about contracting COVID-19 in the workplace. I think a lot of us are coming back into the workplace, and we have been social distancing and quarantining at home for a year and a half, and so there are going to be. I think it's fairly reasonable to expect some employees to have some fears about continuing to be around others as they come back to the office, but unless that's tied to some sort of mental or emotional disability, it doesn't require an accommodation. Just fear doesn't necessarily trigger any ADA requirements. There was just kind of one last situation here that to kind of lead us into more generalized questions. I want to just kind of give this hypothetical. Brenda, a customer service rep, has been teleworking during the pandemic, recently moved to another county that increases her commute from 15 minutes to 3 hours. So she lives much further away now. Traditionally, she interacted with customers in person and on the phone, but has only interacted with customers over the phone during the pandemic because city offices were closed. City decided we're bringing people back effective August 1st. Brenda requests to continue working remotely most days and come into the office only 2 days every couple of weeks. Any thoughts on what kind of things you should consider here, or what should be done?
Anyone have any comments? This is the part where you guys volunteer information or you type stuff in. That would be nice.
Well, one thing to kind of get us into, and I realize some people may have different questions than this, but one thing we just talked about is the fact that kind of teleworking arrangements had become more prevalent or more accessible over the last year or so doesn't have any bearing on whether Brenda should be permitted to telework. There was a recent court case where an employee in a similar situation to Brenda made a claim for race and color discrimination because her employer denied a very similar request to continue working remotely most days. Albeit she had actually moved to another part of the country during the pandemic, so her commute was much longer. The court also found, the court kind of rejected that employee's claims and found that, just that the denial to request the telework wasn't an adverse employment action that would kind of state a cognizable claim of discrimination under federal EEO laws. even though she was actually spending $600 per commute and had suffered damage to her knee making that commute. So, you know, unless this is important because unless it's tied to something like a disability, first, an accommodation is not going to be necessary. And two, just because someone has, kind of made the situation tougher for themselves doesn't necessarily mean that requiring the person to meet the requirements of the job would be an adverse employment action. So kind of leading into, are there any more generalized questions that we can answer? We covered a lot today. Patrick or I are happy to answer any other questions that you may have, at this time.
Looks like you have a few questions here. Let's see. I don't know how most other places have operated, but we never closed. We did not move anyone to remote work, so these issues are not going to be something that's the case. That was a comment. If we offer an incentive and get a lot of people saying that they have religious concerns, wouldn't we have to give the incentive to all?
Actually, that's a great question, and it's interesting in that if you're talking about incentive, the religious accommodation doesn't come into play, actually. So as a matter of law, if you look at my video screen, I'll illustrate that to have a religious accommodation issue, you have to have a rule or a workplace rule that directly conflicts with a sincerely held religious belief. And so if all you're offering is an incentive, it's not a rule. So if you have a mandatory vaccine requirement, then you've got a direct conflict between a religious belief that, hey, I don't think this is within my religion, and a requirement that you have a vaccine. That would be where you would have a religious accommodation duty. And again, as Tim noted in his presentation, that reasonable accommodation obligation is much lighter than an ADA accommodation obligation. But in an incentive situation, the employee has the option to say, well, I'm not going to do it. So you don't actually get into that religious objection kind of situation.
Very good. If an employer requires a vaccine for employment and an employee wants a religious waiver, what proof do they have to provide?
I think what they would generally be able to do is simply explain that I am a member of this belief group or system, and here is the religious belief that's at issue. I've been presented with religious belief kind of situations in the past, and sometimes there's, by a particular employee, a slight misunderstanding of what the religious belief or practice mandates. And so I've actually had calls with kind of the home office of a particular religion to say, we have this situation, the city or county is requiring this kind of protection for employee safety, and we're getting a religious objection from this individual, and the person says, oh no, that's not what we believe. And we're able to actually develop a little bit what the religious belief or practice really is, and then go back to the employee and say, well, we contacted, the main denomination or the main, home office, and here's what we learned, and here's the contact information of the person. And then the person says, yep, I'm willing to do this precaution, that the city or county is asking for. So there's not like a piece of paper that you would do, but you need to have enough information so that you can vet the validity of what they're claiming.
Another question based on kind of the same thing, same incentive question. Does it matter if they are not able to get the vaccine because of medical issue?
So we're talking about an incentive system where somebody can't get the vaccine due to a
Correct.
medical situation? Okay.
Yep.
Yeah, this presents more of an ADA situation where you want to have a conversation with the individual about what their medical condition is, why it's unsafe for them to get a vaccine, and you might even have to do a request to their doctor saying, hey, we need a little more information about this just so we can understand. And then you would talk through with that individual what the options are, which include some of the stuff Tim reviewed, which could be, okay, you don't have to get the vaccine, but when you come to the office, you've got to wear a mask. Maybe even placing them in a special place within the workplace so they don't have as much interaction with other people. Maybe even allowing them to work from home for a particular period of time. Those are all the things that you would want to evaluate in a disability kind of scenario.
Very good. Any other questions out there? Well, if not any questions, I wanted to thank both Tim and Patrick for their time. Great presentation, really appreciated it. And we're going to be doing one more of these, so the session, and that's within a few weeks. So who knows what will pop up in between now and then. Could be totally different. It could be added a bunch of different things. At that point in time, when we do after we do the next session, I will send out a copy of the presentation and a link to the recording. So if you want either of those, hold on just a couple weeks and we'll send it out to all those that have registered for this event. With that said, thank you both so very, very much. Great job, and we will see you next time.
All right. Thank you.
For having us.